Welcome everyone. I'm Amanda Douglas. I think most people know that. I always forget to introduce myself. I am just going to mute you all, not because I like power and control, but most of you are used to the conventions of Zoom by now, and I see most of you are muted. Good to see so many familiar names there, and some new names as well, so that's really good. So today I'm going to talk to you about restructuring and resizing your business. I'm not actually going to talk too much, although I could, but the key driver here was to have a Q&A, so I've got some questions here, and if you've got any questions that you'd like answered, then please do send them through on the chat function. So, you know, depending on which version of Zoom you're using, but on the computer it's usually down the bottom. Click that and you'll get the window up. You can either send it just where everyone sees it, or you can send it privately to just me, and I will answer those questions as well as best I can within the time frames. So it's probably worthwhile just having a bit of a sort of look at where we are and how we've got here. Well, not how we've got here, because we'd be here all day, but there's sort of been a lot happening in the employment world in terms, in light of the COVID and the pandemic and the lockdown, etc. And we're now at the point where we have had a lot of businesses having to make restructuring changes to their operations. And there have been quite a variety of different ways that businesses have chosen to right-size their business. So it hasn't just been through redundancies, although that we have seen a lot of that. We've also seen reduced hours and pay, and hibernation or some kind of temporary suspension of staff for a period of time. And commonly at the moment it might be a business that does not necessarily have high volumes over winter, and so some didn't open at all after lockdown, or some have gone into either skeleton or no staff operations for a period to then see what things look like when we come out at a better season or a better economic climate, depending on the industry that they're in. And the key thing with all of that is that you need to have a process. So the starting point is that an employer cannot unilaterally change the terms of employment, and that's what we're doing when we're doing all of these things, including making someone redundant. So, you know, that process involves putting a proposal to staff, giving them the opportunity to respond after time to consider the proposal, an opportunity to get advice, hearing their feedback, and then being able to make a decision. And there's a heap of fish hooks in the whole thing. And we're always seeing these sort of cookie cutter restructure processes, which really just don't cut the mustard. And the other thing that we're really seeing is an uptick in personal grievances. And that's just purely because employees do not see that they have great prospects of getting a replacement role somewhere else. And so we're seeing a lot of personal grievances, even where their merits are not that flash. We're also seeing a lot where employers have tried to run the process by themselves and they haven't quite executed it as they should, and therefore there is a personal grievance, and that does have some merit. And so we've seen a lot of that sort of stuff happening. This desperation, the other aspect that we've seen are applications for reinstatement. That was changed to be the primary remedy for the Employment Relations Authority to look at. And certainly it's being used as leverage, if not as a genuine application, because staff or those who are dismissed are going, well, I can't get a job somewhere else, so I'm going to fight to go back into the workplace. And as we've talked about in other sessions, that is the most horrifying scenario for a lot of employers, as you know, someone that they've felt that something's serious enough that they go, or that they are in such a situation that they need to downsize, and to have someone return to the workplace can be problematic. So it really is important to make sure that the processes are followed and are done correctly. So when it comes to raising a personal grievance, an employee can raise it on the basis of substance or procedure. So in substance, we're talking about what's the genuine reason to terminate, and in this case we're talking about in the form of a restructure. And was the procedure followed correctly? Now, in a COVID world where a company is, or an organisation is genuinely affected by the pandemic or the lockdown or something related to that, they are likely to have genuine reasons. And that's even more insulting really to the employer when they have really genuine reasons for making these changes that, you know, in many cases the employers are really struggling with that themselves, to then have a valid personal grievance because they didn't follow the steps correctly. And that's the quandary that people end up in, and unfortunate. So maybe if we just have a bit of a discussion around what are the things that sort of tend to crop up, and fish hooks, I suppose. So consultation is one. We all hear about that. Consultation is needed in a restructure process. So what does that mean? Well, it's more than mere notification, but it's not acceptance or agreement. So, you know, you don't have to get agreement with employees, but you have to constructively engage in it. So you're putting out a proposal for consideration. We frequently find staff coming back, asking questions, wanting additional things taken into account, etc. And so to the extent that's reasonable, that should be done. It's a bit of a balance as to whether you engage in the discussion with them during the process, because there's always at least one who's got lots of questions and issues and wants to see information and things like that. And there is a line to be drawn there as to what needs to be and should be provided. The key is to make sure that what you provide from the outset is robust, and then any other information request shouldn't be a big burden on you. Sometimes it's appropriate to respond to those matters when and as they're asked, and other times it's appropriate to just hold on to that, consider it and make it part of your deliberations, and then input into the decision on the restructure. So, so that's, you know, and it's a bit of a judgment call and depends on what's happening and what you can see might happen with this particular thing. But in theory, genuine efforts to accommodate the views of employees is needed. And the concept is that the employer has this working plan in mind, they're putting it out for consultation, but should always have that open mind and that lack of predetermination, which is one of the fundamental concepts of natural justice which underpin this whole process. Documenting the restructure proposal is key. I don't think anyone would get through a successful restructure without putting something out in writing, and I think most people would accept that. But it's what goes into that documentation. So, you know, you need to have the reason and the rationale for the restructure, and it's clearly expressed. And the test I always run is, what would someone coming in cold, is there enough for them to understand what's going on in the business, what's being proposed, and what's the impact on that person? And clearly outlining the genuine business reasons, how that's going to change the current structure, and impacts and effects on roles. So it's really important that documentation becomes your evidence later. People do tend to rewrite verbal history to suit themselves, or that's what it sort of seems to be when you're dealing with disputes coming out of these issues. So it is really important to make sure that you've got that documented. In terms of genuine reasons, that is key. So previously, the Employment Relations Authority and the court did not inquire into business reasons for a restructure, but there's been a gradual shift over the last few years. So, you know, they have drilled down into what it is that the employer is saying as being the reasons for a restructure. So things like employers saying that they're going to make X dollars worth of savings from the restructure, but actually when you drill down into it, that value of savings is not being achieved. So that's been found to affect the genuineness and the justification for the restructure, thus supporting a personal grievance. Other situations where financial information has been incorrect have undermined the justification for the restructure. So it's really important to get those reasons and the information right. Another rookie mistake is around not consulting the employment agreement. So you really need to make sure that's one of the first things that you're doing. Checking the employment agreement, making sure that any process that is set out in that document or in any policy is followed. So, and there's just numerous instances where employers haven't gone and followed the processes that they've got in their own documentation, and the courts just think that's ridiculous and don't tolerate that much at all. There was a situation, one case where there was an employment agreement that had a mechanism for hours to be reduced, which is interesting given what we've just been through in recent months, is that being quite a common approach. So rather than invoking that clause and reducing the employee's hours, the employer made the employee redundant. And the court said, well, that's not genuine because we had this other mechanism in the employment agreement. So in that case, the documents tripped the employer up. Redeployment is a really big thing that we are seeing at the moment. Is we sort of have our genuine reasons, we're drafting it all the way, and then it's like who goes into which roles. Say we might be disestablishing some roles, say 5 roles, creating 3, and those 5 might be going into those 3 or something like that. So there are very specific legal requirements around redeployment. So, excuse me, I'll just mute whoever's talking there coming through. So if the role has been disestablished and there is a role available that that employee can do, then it might be then it's highly likely that you might need to offer that role to that employee. So we often have situations where the employer says, well, we actually just, we want someone better for that role. Restructures are not very good at allowing you to do that if the roles are pretty similar. So where the law has sort of gone with this is that if there is a role that that person in a disestablished position could do, even with some training, then you need to offer it to them. So it's not just, not even allowing them to apply for it, it's this actually redeploying them directly into it. And so that's an area where people can get tripped up. And that's even the case where it might be a lesser role as well. So a lot of the time employers go, oh, well, it's not, the remuneration is not as high, so they won't want it. That's kind of irrelevant. Your assessment as to whether or not they will want that role, you need to offer it to them anyway and let them make that decision. So there are cases where, there are the new position, it might carry more responsibilities, but if that employee can have some upskilling, then they should be offered it. And so in one case where that was instead publicly advertised, the employer fell down and had failed to act as a reasonable employer could have done. So that's something to be really careful about. And when you're getting to that point, of course, selection criteria is an interesting element as well. So when you're if you've got a proposed structure, then you will often have a 2-staged process where you confirm the structure. You would have put the selection criteria out for consultation as well, so you'd be confirming that, and then you need to go through the process of deciding who meets the selection criteria and who doesn't, to determine who's going to stay in roles and who is made redundant. So that might be where you're reducing the number of similar roles, perhaps by 2 people or something like that. The selection criteria is really key in the transparency around how it's going to be applied. And you know, we often have people who have ideas as to who's going to make it through that selection criteria and who doesn't. And of course, you can't be predetermined, but you certainly need to ensure that that selection criteria does reflect the roles that you, or the nature of the role that you want to exist at the end of this process. So that's something that is really important. At the risk of winding on even more, there have been 3 cases now that have come out around regarding the COVID situation. So those of you who heard these Q&As during lockdown, we kept saying, we've got no law, we've got no law, we've got nothing to base it on. And so we were applying employment law principles to an unknown situation, and it worked pretty well, and I think most people have kind of got it right, but my observation from these decisions that have come through is that the Employment Relations Authority, or the ERA, has found ways to come down on the side of the employees where it can. So one of those was around in one case where the applicants or the employees had been sent a memorandum stating that from a certain date they would be paid 80% of their salary and wages until 22 April. So that was lining up with the wage subsidy and with lockdown too, if you recall all those dates sounding familiar. And then later they went through a restructure. And so the point that was heard by the court under urgency was about this reduction of wages to 80%, because that was impacting on how they were paid their notice coming out of that restructure, because their positions were disestablished. And so by sending a memorandum saying we're going to pay you 80%, the authority determined that the applicants had not agreed to 80% of their pay, and in the absence of consultation and agreement to vary those terms, in that case of the notice period, then there was no legal basis to reduce the wages under the employment agreement for those staff members, and that they were ready and willing to work, which is an argument that we expected to crop up during this. So in that case, the employer had to pay outstanding sums about basically the top up over the 80%. And so if you've heard us talking about this before, we talked about the fact you needed to consult and run a process, which didn't happen there. So that's not really a great surprise in terms of that decision. Another decision was very much minimum wage focused, and it was a business, it was in-flight catering, so they were an essential service, which I think is a distinction as well. So they were allowed to operate during level 4, but of course they didn't have much business. So they partially shut down their operations. And so they did propose a partial shutdown, and that employees were paid 80% of their normal pay, and that they could choose to top up to the 100% by using their annual leave, which was another thing that was happening. Then the minimum wage increased. You'll recall 1st of April, minimum wage rate went up, and initially the employer said, well, if you are attending work, you'll get paid the new minimum wage rate, but if you're at home getting paid 80%, then you won't. And so there was it was really a big hoo-ha about what is working for the purposes of minimum wage, really. And so the authority said, well, payments at 80% were payments of wages. And the thing with these guys is that they were mostly all on minimum wage as well. So any change to your minimum wage is going to impact, because you're not supposed to pay less than minimum wage. So that's all very circular. So because the payments were payments of wages, they were subject to the Minimum Wage Act. And you can't agree to an arrangement that sees someone getting wages less than the minimum wage, also, they were found to be really willing and able to work, and I think the essential services side of things impacted too very much on that. So they were entitled to be paid for work they did carry out, but also work they were contracted to carry out but may not have carried out. And the reason that they weren't working was not due to COVID, the authority thought, but actually because the employer had directed them not to. So that was a distinction that was important. So once again, the employer had to compensate the difference between to make sure they were paid the correct minimum wage. So that one effectively became a minimum wage issue. And then there's been a third one involving Solly's, which was in the news, can't really say the newspaper anymore, can you? Late last week. So there were a bunch of staff members who were made redundant, which they challenged. And although they could operate in level 4, they couldn't carry out the non-essential part in terms of freight carrying. And so there were quite a few issues identified, and there was a lot of toing and froing about whether or not these people were included in the wage subsidy application, and the employer was sort of blaming the wage subsidy, waiting to find out whether that was being granted. And then there were discussions with MSD about taking people off the list, because as you recall, there were declarations that were made about the wage subsidy, etc. And there was some predetermination with that, because the people that some of the ones that were ultimately made redundant were taken off the list, but it was before they'd heard from them. So in terms of the process, etc., there were some obvious issues. So they said, look, this issue about the wage subsidy application and not knowing about it was not really a material factor in making the decision. And so that was one of the reasons being relied on for the restructure. So that meant it wasn't genuine. There wasn't proper access to information on the material matters about continuity of employment, and no opportunity to comment on it. There were breaches of good faith, and they failed to use the best endeavours to retain those named in the wage subsidy application. So they were entitled to that because they were named in the application. So there was a range of errors that probably on a general context we would say are problematic. So I think really the lesson that we learn from that is that it's really important to make sure that you've got the right process and that you do things carefully. And that, you know, being aware that there's this increase in making claims for personal grievances. So I haven't done much to answer many questions, so I'll go on to that now. One question I've got up on the board, can you ask for restructure plan if you were an employee involved? I guess that would only need to be a basic document. I'm not sure what we mean by that. Do we mean a restructure proposal, or do we mean an organisation plan? I'm not sure. But an employee, I guess it comes down to the employee is entitled to have information about a proposed decision that impacts on their employment. So they are entitled to have the information about why. Proposal plan, thank you, clarified. Yeah, absolutely. So the employee should be provided with the proposal because yes, that is what is up for discussion, and the details around the reasons. Sometimes it's quite useful to have an organisation chart now and propose, but that's not essential, and it depends on what's being proposed. Spelling out the impact on the employee and that sort of stuff. So yes, and then the employee needs to have the time to consider that before they provide some feedback. The feedback can be done in a variety of ways, and we were a little bit innovative when we weren't allowed to go out and see each other. So video conferencing has become quite popular. Putting feedback in writing as an option, and meeting with staff as well. So those are all options there. Some of the other questions that have been sent through ahead of time. We want to propose changes within our business which would affect a number of junior roles. What process are we required to follow in selecting roles for redundancy, and can we use last on, first off method? So we've talked a bit about this. The last off, first off method is something that everyone knows about, but there's really no employment law basis for it. So I would steer away from that as much as possible, unless you have that written in some policy that that's what you're going to do. And I think that would be unusual, because wouldn't it be a shame if the last person you hired was your star? So most people shouldn't or wouldn't have that in their policy. So the principle for selection is that we need to look at who else is in a similar role or the same role. So if you've got several people with the name solicitor, say, well then all of those, and they've got the same position description, then arguably you would be looking at all of those, say we're reducing by 2. So all of those would have the proposal provided to them. And we would then develop the selection criteria. And as I said before, that is key to determining who we're going to select for redundancy effectively, although you're really selecting who stays technically. And so what you put into that is key as to what you want to have come out. So you might want to have people with, what we've seen a lot is where we're reducing staff numbers, people are wanting to keep those who have got multiple skills and a lot of experience, so they can jump and do a lot of different tasks rather than being confined. Unfortunately, that has seen a lot of junior people going, actually, because you tend to get that experience and breadth of skills as you have been around for a wee while in your industry. So those are the things that I would suggest, and then you need to go through and actually score people against that criteria to then work out who is going to stay and who will go, and usually the lowest scorers will be the ones that go. Feel free, everyone else too, to send through any questions that you might want to send through, if any burning issues on your mind. Do we need to meet with every affected employee to receive their feedback? Yes. Yes, you do. Although in some cases you need to receive their feedback. So in some cases we may receive it in writing. It's good if you're doing that to give the option of meeting in person, and also having a think about what are the skills and qualities and access to resources for your staff members. So for example, we did one restructure where there are a lot of factory workers, so they don't have access to a computer as a part of their work on a allocated computer. And a lot of them had, some had English as a second language, and some had limited literacy skills. So in that situation, we did a bit of a form for them to fill in, or in other cases, we've tailored it to the audience, basically. So that's something that's really important, so that you're actually giving employees a genuine opportunity to respond. And so you may find that some groups of workers may respond better to having a meeting where they can say what they think without having to write it down. And that's a very real issue for a lot of workers. So, so that's something to bear in mind. What are examples of appropriate selection criteria? It's going to depend on what we're trying to achieve. But like the element that I was talking about before, breadth and depth of skills and experience. There might be, you can put things in like the cost of the role, because that's a very valid consideration. Things like attitude, work ethic, professionalism. You can put previous history with the company, you've got to just be a little bit careful about how that's phrased, etc., because there is a danger in keeping, you want to keep the idea of a restructure separate from a performance matter. So you don't want to be accused of running a restructure to solve performance matters. So you've got to be careful not to conflate that, and there are ways of achieving that. For some sales roles that might be around, the sales achieved and productivity and profitability for the business and that type of thing. So it's just really a matter of sitting down and working out what best suits the role that you want to have standing and the people in that. And just coming to my last question, so if anyone else has got anything there, feel free to put it up while I'm doing that. What time frames should be allowed for consultation with staff during a restructure? There's no prescribed time frame. The general principle is that you need to give them a reasonable period of time to consider what you're proposing, to get advice if they want to, and to prepare a response. So at least 3 working days, really. It could be longer, it could be shorter, probably not shorter, it could be longer. On the flip side, there are many restructures that go on for far too long, and they create quite a lot of uncertainty in the workplace. Even if it's not people who are directly being consulted with, it causes unrest, doesn't it? And then there's a large number of people that say, I was in a restructure process for weeks, if not months, and that is just a terrible place to be. So it's about striking a balance, and once again, looking at the needs of the employees and the business, etc. It probably is sort of around that 3 days to 1 week, depending what we're looking at. Some employees will ask for extra time. That's quite difficult to manage when you're consulting a large number of people, and some are responding and some are asking for more time. But it is something that you do need to seriously consider, and in most cases you would be likely to give them that, so that in reasonableness, and provided that it doesn't cause other difficulties. Certainly we find that when employees ask for more time, you've then got the rest of the bunch of them who are then being left wondering what's happening. So it's a real balancing act, and we've got one at the moment where we're just trying to balance that, because it's, you've got to be fair to everyone, but it's quite hard to, please everyone. Another question up here. Change process started pre-COVID, was delayed. During the process, the original rationales have significantly changed due to the environment. Can we refresh the rationales and update the documentation and circulate to the team for renewed feedback, and simply extend out the consultation phase, or do we need to start all over? Absolutely, you can do the option that you suggested of refreshing. So keep it as part of the process. It's a bit more genuine, and open. Yes, we had this process, and in fact I'd say, we started this process, since then we've had these things, and these things are now impacting, and so we want to hear what you have to say. It's almost effectively the same as starting again. The caveats to that would be, by making it an extension of your current process, it means if you've got some detail on that first documentation, you don't need to repeat yourself. So it can be quite good just to say, well, these are the new factors, and please look at our other documentation for everything else. So that's quite good. But if there are any irregularities or issues with that beginning process, then that might be a reason to have a defining line and perhaps say, well, that's at an end, but we've actually got a new process, so that this part is not tainted by what happened before. So that would be my suggestion. Cool. Any more questions? Okay, well, you know where we are. We're at the end of the phone or the email. Lots of people have been making time to just have a bit of a talk with us about where they might go with the changes that they need to make. As I said before, it might not necessarily be redundancies, it might be sort of reduced hours or some other changes, but really that right sizing of the business is really important at the moment. We're sort of feeling like we've got through reasonably okay, well certainly better than most businesses thought they would in light of the lockdown, etc. But there are also lots of others who are hurting quite badly, and I think the message that we're hearing from most employers is that that prudent management, which includes right-sizing their business, is really important to them. So there's a lot that are going through that process. And as I said before, really important to make sure that that's done right because of this appetite out there to raise personal grievances and really give it a go. So feel free to reach out if you want to have any discussions along those lines. When it comes down to, people have sort of preconceived ideas about where they see the structure going, but sometimes it's a bit tricky to fit the legal requirements to that. So that's really a really good sort of strategic discussion to have going forward. So thanks for your time, everyone, and good luck with your employment issues, and let us know if there's anything we can do to help. Thank you all. We'll see you later.